like to first uh, just like to first welcome. Do we do a roll call first, David? Yeah. So if we could just do a roll call, I guess I'll go through the names. So we have Jody DeLallo in Albany, myself, Derminder Bassett. Okay, Dale Burnett is here.
Here.
David Dworkin is here. Thomas Grabinski.
Here.
Kristalia King, not here. Trish O'Connor indicated that she was not feeling well. Shauna Menifee is not here. Diane Ramirez, Greg Weston is not here. Sandhya Espithia is here, and Caroline Burton is here. Additionally, do we have any other, I guess we'll introduce, if the staff in Albany could introduce themselves, we'd appreciate that.
I'm Candy Burchett, Department of State.
Heidi Hicks, Department of State.
John Clement, Department of State.
Emily Lupi, Department of State.
Terrific. I think Buffalo already introduced themselves. And then if members here in New York State, Jack, we start with you.
I'm Jack Palillo with the Department of State.
Matthew Wolf of the Department of State. Dave Mossberg, Department of State.
Terrific. Did we miss anyone? Okay. I'd like to start by welcoming a new board member, Tom Grabinski. Tom, welcome to the board. If you don't mind, if you just say something quick about yourself, we'd appreciate that.
So I look forward to working and learning and growing and just helping make the overall real estate market even better, and really focused on the learning aspect of it in terms of continuing again and things of that nature.
Terrific. Tom, are you a real estate broker? What's
A
your...
real estate broker by trade. I finance commercial real estate here in upstate New York. I've been doing it for 20 plus years, and I kids, 3 kids and a wife, live here our entire life.
Great. Thank you, Tom. Welcome to the board.
Appreciate it. Thank you.
We fortunate we have 8 members of the 15, so we have a quorum today. So congratulations to all of us.
That's what 2 years is
Glad that
taken.
we finally have been able to do that. We had previously sent out meeting summaries. If I could just have, if someone could make a motion to approve the meeting summaries.
I didn't make that
Okay,
motion.
Mayor Ramirez, thank you. Do we have a
Second.
Thank you.
I'm
Okay,
sorry, who
so,
seconded?
Dale Burnett.
Dale.
thank you. So now we're going to do department and subcommittee reports. Jack, if you could, the enforcement report.
Yes, of course. So I'm here to report the following today.
I'm sorry, one
Sorry.
moment. Can you guys hear me? This
Yes,
is the court
yes.
reporter. Your audio is going in and out. I can't capture everything. Do you want to proceed this way?
Is it?
Every time someone speaks, it's like cutting them in and out. I'm not sure.
I mean, we could try to bring this microphone closer to the, no, like, or just to.
So is it possible to put everyone on mute other than New York while we're doing that? Could we do that? Could we try to put everyone else on mute?
Are we able to do that, Liz?
Everyone except for New York at this point.
Okay, Liz, and then when we do Emily and Heidi, we can mute New York and let's see, and then go to Albany. We'll see if that works.
Okay,
Okay, thank you.
thank you.
How would we know, though, if the court reporter can't hear
Well,
us if
let's-
she's on mute?
Well, I'm hoping that she comes back in and lets us know how it's working.
No, but if Liz
See,
muted
even
her.
with
No.
even with you talking right now, it's still going in and out. I can't capture everything you're saying.
So I think, you know what, my feeling is do the best you can, and I guess we'll take some notes and we'll do it that way. We'll do it the old fashioned way.
I have
Yeah,
okay.
it-
I have my backup audio and stuff on still. So if you want to proceed, that's fine.
Yes, we'll proceed. Thank you.
Okay, you're welcome.
I guess we just asked that if she has access to the
to the Zoom, it's recorded.
Yeah,
Yes.
it'll be on, it should be actually live streamed, and it'll also be posted on the department's YouTube page following the meeting.
Okay. So I think we should be good. So Jack, if you could share with us your enforcement report.
Sure. So this is Jack Balello in the enforcement report. I have to report the following. During the period of June 1st, 2023 through June 4th, 2024, the department opened 640 real estate complaints. During that same time frame, the Department of State Enforcement Unit closed 455 real estate complaints. And currently, the Department of State is investigating, as of today, 700 real estate complaints. And that is the report for today.
Okay. Jack, do you know, you may not, but just curious, how many licenses were actually revoked or suspended in that time?
That I do not know.
Okay, so maybe we could do that next time.
Sure.
Okay.
So I just want to make sure I understand it too. I'm pretty sure I've asked this dumb question in the past. So 600 new, 400, 200, 700, so there was 500 existing rolling in.
Yeah, so, yeah, we definitely had open complaints prior to receiving those new ones. But as of today, as of today's date, we have literally 700 real estate complaints that are being investigated.
Okay. Thank you, Jack.
You're welcome.
So we'll go to Emily Lupi for the processing report. So if we could make Albany live.
I apologize. I am unable to do it on my end. I keep hitting on mute for Albany and it's saying request sent. I think it might have to be hit on the screen. There we go.
Hear us?
Yes,
We can hear
thank
you.
you, Candy.
You're welcome. Good afternoon. Included in the materials you were provided is a report of the number of current real estate licensees for April of 2023 and April of 2024. The report groups licensees into broker and branch office licenses and salesperson licenses. The totals are listed by county. The numbers are fairly consistent. The total number of licensees in 2024 is slightly lower than 2023 at the same time. However, the overall change is about 3%.
Does anyone have any questions for Emily? Okay. With that, then we'll go to Heidi for the examination report.
The following statistics cover the first quarter of 2024. The real estate salesperson examination was administered to 4,838 individuals with a pass rate of 54%. The real estate broker examination was administered to 328 individuals with a pass rate of 53%. Compared to the last quarter of 2023, the pass rates have remained fairly consistent with a 2% decrease for sales and a 3% increase for broker. That's all I have.
Heidi, are we back on schedule now with respect to people being able to take the exams when they want to? For a while, it was kind of spaced out, but is the availability
Yeah, I
now?
believe so. We have plenty of space, plenty of locations.
I tell you, it was very busy out here when we just came up, so it's good. Okay, very good. Okay, under new business, I'm going to hand it to David Mossberg to discuss New York attorneys for continuing education.
All right. So this has been something that I think we had discussed briefly at prior meetings, though there wasn't a quorum, which is there's a provision in the New York real property law that concerns continuing education requirements for real estate brokers and salespeople. And there's a sentence in there that discusses the faculty requirements. The law states that it shall be taught by qualified faculty with attorneys presenting legal subjects. there was a question presented to the department about whether or not that sentence is limited to attorneys licensed to practice within the state of New York or any bar admitted attorney in any jurisdiction, or would that individual be qualified or be an appropriate person to teach these courses. So I've looked at the law and basically the opinion that we have in the counsel's office side is that there's definitely an ambiguity, but that in all likelihood that phrase was intended to be limited only to New York attorneys practicing within New York State. The justification for that in part is that this law was originally passed in 1977, hasn't been amended since. So thinking about what the legislature would have thought when they used that phrase in 1977, when there's no Zoom virtual meetings or anything like that, it would have been likely that they would have anticipated the attorney to have a practice within New York State. In addition, there are other provisions within the same article of law, within Article 12A, which discusses attorneys and attorneys at law, and they've been court cases and opinions of the Office of the Attorney General that have said that that should be applied only to New York attorneys. The reason being is that New York attorneys are subject to the jurisdiction of the courts of New York State. They've been vetted by, the appellate committees when they've got their law license, so they've been able to demonstrate sort of the trustworthiness and the character requirements to satisfy licensing. So given that, we believe that the most reasonable interpretation of that statute based on other authority as well as the intent is to limit it, what we wanted to present to the board for consideration is whether or not the board wants to clarify this issue through the regulatory process. So we don't have, a draft regulation or anything to present now. We don't know really whether or not this is, a big concern, whether or not there are a lot of attorneys not practicing in New York that are trying to become, continuing education instructors. But because this was a question that was presented to the department, we wanted to present it to the board so that if the board wanted us on the council side to start working on a regulatory rulemaking, we can, and then we would clarify what we believe was the intent, which is if you're going to be teaching one of the various legal subjects required for continuing ed, that you be a New York State licensed admitted attorney. So that's the purpose of, this item on the agenda, was to present this to the board so that the board can discuss it and, if appropriate, advise on whether or not a rulemaking might be appropriate. So I'll open it up to the board members.
Is there any instance we know of in practice someone teaching a course that is a Maryland bar
Do we
attorney?
have data on that?
So this was presented, my understanding, and again, this has been on the agenda for some time, so I don't know if the information is current, but it's my understanding that there may, it hasn't been verified to me, that it may have been a single instance of somebody out of state who had applied. I don't know if that individual still is an instructor. I don't know if that individual went and, through reciprocity or other vehicle got a New York license, but I don't know.
Seems hard. I hate to make work. It seems hard not to clarify it. It doesn't seem like, actually, it probably makes sense to clarify it in peacetime. Like before it does happen and there's an issue, but that's my thought.
Well, I mean, it's up to the, obviously the board. Rulemaking like this would require board vote approval, and then it would go through the entire regulatory process. So,
How long will it take for the changes to be in place?
on average, the regulatory rulemaking process, I would say a minimum of 6 months. Because what would happen is, if the board felt that this was a significant enough issue to be addressed by a rulemaking, at the next board meeting, hopefully by then, myself or, perhaps another attorney from our office would present the rulemaking, the actual text. In this instance, it's probably not going to be all that difficult to write, a rule that just clarifies, pursuant to RPL 442, whatever the rule is, that the attorney has to be a bar admitted attorney. We'd probably be able to present that at the next meeting if the board wanted to clarify this issue.
So I'm recusing myself substantively from this conversation. I'm an attorney. I have a real estate school, so I'm not. But from a procedural perspective, it seems to me, Dale, that that if they go the regulatory route, there will be a public comment period, and then if someone wants to weigh in and say, look, I'm not in favor of this, then we'll hear about it. So I think that's probably makes sense. That's probably the best way to go. And it may take up to 6 months, but at least there'll be an opportunity for the public to comment, any trade association, whoever would like to comment on it, and then we will vote as a board, right?
Right. So customarily what would happen is we would present the actual text change to be added to Title 19 to the board for vote. Past experience, the vote has usually been something to the effect of that the board authorizes the Secretary of State to take any and all action necessary to propose the rule and also adopt as a measure following the public comment period if there's no revisions required. If during that public comment period, which is required, if something comes back where we need to suggest the change, we'll come back to the board, and then the board will have to vote a second time. But usually it's presenting it in one meeting for the board and adopting after the public comment period.
So what do we need to do today? Do we just need to instruct you to pursue that? Do we need to take a vote on that piece, or can the board?
The board would, now that there's a quorum, the board can say, yeah, we would like the Secretary of State's office to prepare, a proposal to clarify this question around,
Support of that.
So let me do it
the rule.
this way. Is there any board member that is opposed to the David and his team moving forward with respect to clarifying this? Okay. Is that?
Okay.
That means okay.
So hopefully at the next board meeting, myself or somebody in our team will be able to present the text. Again, I don't imagine that the actual text of the rule is going to be, something long or complex. It's not going to be like the real estate fair housing rules or the advertising rules. It's probably going to be very short and direct, but it will hopefully clarify this issue.
Okay. We're going to give you one more thing to do then, Dave.
Feel bad.
No, that's what we're here for.
Okay, and then I guess the second item.
So the second item is somewhat related in terms of presenting this idea to the board to get a decision on whether or not we should be presenting a proposed rulemaking at a next meeting or a future meeting, which has to do with student lists for schools. So currently there are 2, 3, 4, 5 regulations that relate to real estate schools, requiring them to submit to the Department of State, it's usually within 15 days following the completion of the course, the actual student roster. The rule, requires it to be submitted basically in paper form, and it requires them to send us this list automatically. There was a proposal by the governor in the State of the State address from last calendar year that thought it would ease burdens on schools, be more environmentally friendly, and more business friendly, to eliminate that mandate where they're required to do that in every instance. And the proposal would be rather to allow them to maintain these records, which they're currently required to do anyway, so that they would be available to the Department of State if we ever needed to conduct an audit, but it eliminates this automatic mailing, this physical paper mailing process within 15 days. So because the regulations are in Title 19, we would need to present it to the board to see whether or not the board likes this proposal or agrees with the proposal, such that the legal team could go back and prepare a regulatory proposal to amend it in line with the governor's proposal to ease the burden on schools and be more environmental friendly.
I have a question on that. How would you get the data otherwise?
How would we, well, so when the applicant applies, they usually provide their school
So you
certificate.
already have their data.
I believe so. I mean, I think somebody from our Albany process.
Honest, it's data that we really don't need. We don't use it to cross-reference or to qualify someone for a license. They have to submit course certificates anyway.
That's right.
And they're required, I
That's how you
think,
get
to
it.
keep.
Right.
Yeah, so it's really information that we don't need. It was originally a protection in case the school went out of business, but we really have no mechanism to track it anyway. So it's not useful in most
Yeah,
instances.
It doesn't sound like you're doing anything with it.
yeah, exactly, because you need licensee data, not data, right, ultimately.
Right, so if anything, this data would be, the utility to it would be to confirm that the student applicant qualified for the license, but if they're giving us the certificates,
That's what I've
and we can always go to the school afterwards.
Your licensee.
It's,
Right.
New York is still very much an honor state, meaning
Yeah.
that it's a representation by the licensee that they've done what they're supposed to do. And then, based on either specific audit or random audit, it will be determined whether they in fact did that. So again, it's not really serving any utilitarian purpose.
Yeah. I guess the issue becomes how you instruct schools to keep that data for data integrity purposes if there's an audit at some point. Just like what kind of governance do you want in place if you were to open a claim or an audit on data that is not a DOS anymore, it lives within the school.
So we would be able to incorporate into like the revised text that we would present, a retention schedule. So I believe the schools are currently required to maintain these records anyway. So that part of the law wouldn't change, but we could clarify that to say that like that obligation for the school doesn't change. So if, Section 177.4 already required them to keep it, like they're keeping it. The only difference is they're not also mailing us their copy.
That makes sense.
So we could certainly clarify that. And again, the idea would be is one, just to get a sense from the board, whether or not the board wanted to move forward with this proposal such that at the next meeting or future meeting, the council's office team can present all of the changes. So there would be a minimum of at least 5 different regulatory proposed changes, just because this requirement exists in at least 5 different sections of the law. So, some of the changes are going to be a lot different based on like what the existing regulation says. So in some instances, I can see that, we would be able just to repeal the entire section. In other regulatory proposals, I suspect that it wouldn't be a repeal, it would be like an amendment. And then we would probably need to do something just to add a new section to clarify, any authorized provider is still required to maintain these records pursuant to, their current retention schedule. Under the state technology law, and they would be able to maintain an electronic digital format anyway. So it's really, I think, the proposal by the governor was really to make things more efficient, more, in line with probably the way that the industry would like to do things, which is electronic and save things like that, and cost of mailing and, the risk of liability if they didn't do it within 15 days.
David, looks like David's trying to get our attention. Elizabeth, can you unmute Rochester?
I'm gonna try to unmute everyone and then just mute the other individuals. It's not unmuting on my end. Are you able to, is there anything on your end?
David, do you have a little white thing on your table?
And it's not unmuting? No.
Candy's looking into it.
I'm trying to unmute them as well. Let me just double check.
It looks like that worked. Did that
It
work?
looks like that
No.
worked.
No.
Before
It did,
worked.
but then it went back on.
Can you try one more time, pushing the button?
There we
Oh,
go, there we go.
Good?
oh,
Okay.
Yes. Yeah, David.
No, I
No,
think he's still-
can't hear him.
Okay, try again. Sorry.
I think he still needs to hit a button.
Yeah.
Yep.
There has to be a button on the screen. Maybe it's one of these where you can touch it.
I don't know. David, do you see any button that you can press?
Or maybe on
Candy.
this screen.
Are you
Might be a
familiar
touch
with it?
screen.
I'm not familiar. I'm texting, or I'm emailing
Okay.
Barbara
Okay.
right now.
I'm having a tough time unmuting Buffalo. Buffalo, are you able to unmute on your end?
No, Matt.
This is unmuted. Can you hear us now?
Yes, we can hear you. Thank you.
All right. And then I'm going to put you back to mute on our side.
Perfect. Thank you.
I wonder if it's the equipment.
David, do you want to call my cell phone and then?
Were you on speaker?
So David, my cell phone is
Wait,
516.
that's going to be public to every single person. That's
Oh.
watching.
Oh, yeah.
Maybe we don't want to do that.
I emailed my contact in Rochester, and hopefully she can come in and help.
Your phone would have become the public comment hotline.
I get enough phone calls as it is. I am the answer man for. Well, I'll tell you what, let's continue on. We'll see if we could figure this out. So from my perspective, again, I'm going to recuse myself substantively from this conversation, but from a procedural perspective, it seems to me that we should give you the authority to go forward this rulemaking because you're going to still propose it to us. And if we have any comments or questions during that comment period, we can make those comments at that time.
Correct. So if the board agreed that this would be, obviously in the best interest of the licensing community and also the schools, that they wanted to advance this, we would present it. The board would see all the proposed rule changes, could ask any questions, and then it would go through the rest of the
Okay.
rulemaking process.
So based on that, is there any board member that is opposed to David and, again, team going forward with creating this proposed rulemaking? David, give me a thumbs up if you're okay with this.
Thumbs up. Looks
Okay.
Okay.
Okay, so I think we're good.
So hopefully we'll have something for the next board meeting.
Okay, thank you. Is there any other new business that anyone would like to bring up for this meeting? Okay, if that's the case, we're going to adjourn this portion of the meeting, and then we are required to have a public hearing session. And David, I'm going to let you take that away.
Okay. All right. Thank you, Neil. So pursuant to New York Real Property Law, Section 442I, Paragraph 6, the board is required to meet no fewer than 3 times and 1 public meeting in New York City, Buffalo, and Albany. The purpose of these separate meetings is to solicit from members of the public suggestions, comments, and observations about real estate practice in New York. So I will ask if there are any members of the public in Albany that wish to provide public comment regarding real estate practices.
No public here.
Okay, and there is no public members in New York City either. Accordingly, pursuant to RPL 442I paragraph 6, this special meeting is closed. Thank you, everybody.
So I'd like to thank everyone for attending. I'd like to thank the board members in particular. Thank you for attending. We actually were able to get a quorum. We've made an effort to bring more substantive issues to the table. We will continue to do that. Thank you, Department of State, and for hosting and for all you do. And this meeting is adjourned.
Thanks, everyone.
If someone can send me whatever